On Friday, March 25th, 2011, within the confines of the apartment they had been sharing for less than a month, the 2006 Duke Lacrosse accuser, Crystal Mangum, was given a cashier's check by her boyfriend, Reginald Day, which he had purchased earlier that day in the amount of $300. Day was listed as the remitter, and the payee was Country Scene Apartments. Its use was to go towards part of the April 2011 monthly apartment rent. Mangum was told to hold on to the cashier's check until Monday, April 4th, 2011, at which time she was to take it, along with another cashier's check, to deliver to the apartment manager's office while Day was at work. No one else witnessed the physical transfer of the cashier's check from Day to Mangum, Mangum taking the check and placing it inside her black purse. She would not remove it from her purse. A week later, on Friday, April 1st, 2011, Day gave Mangum a second cashier's check in the amount of $400. This check, along with the one of March 25th, 2011, was to pay in full the April month's rent on their apartment. As before, Day was the remitter. Country Scene Apartments was the payee. The physical transfer of the cashier's check from Day to Mangum took place within their apartment. Mangum immediately placed the check inside her black purse. The transaction between the two was not witnessed by anyone else, and Mangum would never remove the cashier's check from her black purse. There is no evidence or proof in the totality of the prosecution discovery in Crystal Mangum's murder case in the death of her boyfriend, Day, or third-party eyewitness to Crystal Mangum stealing or illegally taking and carrying away any cashier's check or money order. Nor is there any evidence or proof or eyewitness to support that Mangum stole or illegally took and carried away any cash money that belonged to Day. In the wee hours of Sunday, April 3rd, 2011, following a jealous tirade by a drunken Day, Mangum poked her abusive boyfriend with a steak knife in the left side of his torso while he was straddled atop her, choking her, an act of self-defense on her part. Inflicting this injury enabled Mangum to escape his control, gain her footing, grab her black purse containing the two cashier's checks, and flee the apartment. Day, an alcoholic, was transported by ambulance to Duke University Hospital shortly thereafter with a non-life-threatening wound. He had the luxury of a thorough workup, including lab, x-rays, and scans, before being taken to the operating room. Surgery being a complete success with a post-operative prognosis for a complete recovery. Unfortunately, on Wednesday, April 6, 2011, his third post-op day, he became severely agitated secondary to impending delirium tremens and was transferred to the surgical intensive care unit. Catastrophic medical malpractice with the intubation of his esophagus instead of trachea took place, which eventually resulted in Mr. Day's brain death and comatose state. There would be no media coverage of this event. A week later, on Wednesday, April 13, 2011, following a lack of neurological improvement, Day's family gave permission for him to be removed from life support, and he died. The North Carolina Deputy Chief Medical Examiner conducted an autopsy the following day, which he documented in his autopsy report. The ME's report contained no mention of the esophageal intubation, a cardiac arrest, post-intubation coma, and Day's placement on life support and its elective removal after 1 week. At the time of his death, media coverage on Reginald Day resumed, but without mention of the esophageal intubation, cardiac arrest, or his life-supported week-long comatose state. On Monday, April 18th, On Monday, April 18, 2011, a grand jury was convened to consider upgrading the prevailing charge against Mangum of assault with a deadly weapon with intent to kill. At that hearing, the state of North Carolina, represented by the Durham District Attorney's Office, had but one single witness, Durham Police Officer Marianne Bond. There was no medical examiner, coroner, or health care professional present to testify before the grand jury. Based solely on the Durham District Attorney's Office's presentation and the testimony of its only witness, Officer Bond, the grand jury handed up 3 indictments. The first, file number 11-CR-02607, was murder in the first degree defined by State Statute 14-17A as follows, quote, murder which shall be perpetuated by means of a nuclear, biological, or chemical weapon of mass destruction as defined in General Statute 14-288.21, poison, lying in wait, imprisonment, starving, torture, or by any other kind of willful, deliberate, and premeditated killing, or which shall be committed in the perpetration or attempted perpetration of any arson, rape, or a sex offense, robbery, kidnapping, burglary, or other felony committed or attempted with the use of a deadly weapon, shall be deemed to be murder in the first degree, a Class A felony, unquote. Based upon the presentation before them, the grand jury made the following averment, quote, the jurors for the state, upon their oath, present that on or about the date of offense shown, and in the county named above, the defendant named above unlawfully, willfully, and feloniously did of malice aforethought kill and murder Reginald Day, unquote. The second and third indictments of file numbers 11-CR-02608 and 11-CR-02609 were handed up by the grand jury respectively for larceny of chosen action on the cashier's check of $300 and larceny of chosen action on the cashier's check of $400. The charge was based on North Carolina General Statute 14-75, which reads, quote, larceny of chosen action. If any person shall feloniously steal, take, and carry away, or take by robbery, any banknote, check, or other order for the payment of money issued by or drawn on any bank or other society or corporation within this state or within any of the United States, or any treasury warrant, debenture, certificate of stock, or other public security, or certificate of stock in any corporation, or any order, bill of exchange, bond, promissory note, or other obligation, either for the payment of money or for the delivery of specific articles being the property of any other person or of any other corporation, notwithstanding any of the said particulars may be termed in law a chosen action, that person is guilty of a Class H felony, unquote. The jury's similar averments on each count of this larceny indictment read as follows, quote, the jurors for the state upon their oath present that on or about the date of offense shown and in the county named above, the defendant named above unlawfully, willfully, and feloniously did steal, take, and carry away another's chosen action, a cashier's check in the amount of $300 and $400 issued by the State Employees Credit Union of the value of $300 and $400 from the possession of Reginald Day, unquote. This true bill by a grand jury of 12 or more jurors was, like the murder indictment, based on the presentation by the Durham District Attorney's Office and the testimony by Durham Police Officer Marianne Bond, the only witness before the body. It is important to note that neither a larceny nor larceny of chose in action charge was levied against Mangum when she was first arrested following the Sunday morning, April 3, 2011, stabbing incident to accompany the assault with a deadly weapon charge. It was only after Day had died and Durham District Attorney's Office sought to upgrade the assault charge to murder that the larceny of chose in action charge was instituted. The reason for adding the indictment on this charge is simple. As is stated in North Carolina General Statute 14-75, larceny of chose in action is a Class H felony. A simple larceny charge would not suffice because the monetary amount involving the two checks combined was $700, which would make it a misdemeanor as it is far below the $1,000 threshold required for a felony. The Durham District Attorney's Office needed a felony charge against Crystal Mangum in order to elevate their murder charge to first degree through use of the felony murder rule. Therefore, in order to justify a first-degree murder charge or indictment, the prosecutors had to couch Day's death, allegedly at the hands of Mangum, to have occurred during the commission of a felony crime, albeit a Class H felony. First-degree murder is a Class A felony, which automatically subjects a criminal defendant convicted to death or life imprisonment without parole pursuant to North Carolina General Statute 14-17. Clearly, it was the goal of Durham District Attorney's Office to have Crystal Mangum imprisoned for life. Though the pretext for this harsh sentence was for her murdering Day, the truth behind the sinister and aggressive prosecution against Mangum was as retribution for her 2006 sexual assault accusations against 3 Duke Lacrosse student athletes. Cultural and racial issues being unavoidable, as Miss Mangum is an African American and the 3 Duke defendants are white and hail from families of wealth, stature, and privilege. After then North Carolina Attorney General Roy Cooper's April 11, 2007 promulgation, in which he dismissed all criminal charges related to the 2006 Duke Lacrosse sexual assault case and declared that the 3 defendants were innocent, the accuser, Crystal Mangum, had crosshairs of retribution placed on her by the state, court, and media. Vengeance against Mangum presented itself with the April 3, 2011 stabbing incident, 5 years after the Duke Lacrosse alleged sexual assault. The media describing as fact Mangum as the false accuser in the Duke Lacrosse case without having any proof for such a deliberate assertion. Retaliation was in the form of the first-degree murder prosecution, seeking a life sentence without the possibility of parole in her boyfriend's death. In order for the Durham District Attorney's Office to obtain a second-degree murder conviction, it had to rely upon criminality by prominent state witnesses. The medical examiner not only produced a fraudulent autopsy report consisting of fabricated findings and a false conclusion that Day died secondary to complications of a stab wound to the chest, but provided perjured testimony contradicted by the operative report as well as his own autopsy report of April 14, 2011. The murder charge against Mangum was built on the fraudulent autopsy report document. Of this, the prosecution was aware, and its April 18, 2011 presentation on that charge before the grand jury had only Durham Police Officer Marianne Bond as a testifying witness. Likewise, Officer Bond, being the only witness, was the only one to testify before the grand jury about the alleged larceny of chose in action. Bond's testimony under oath, along with the Durham DA's office's presentation, convinced the grand jury to hand up the 2-count larceny of chose in action indictment. The problem with the state's case is that both Officer Bond and the Durham DA's office was aware that the larceny of chose in action charge lacked probable cause. In fact, both parties were aware of the truth that Mangum was innocent of the charge. First and foremost, Officer Bond had interviewed Reginald Day on Monday, April 4, 2011, one day following his surgery. During that interview, Bond wrote in her report thusly, quote, Mr. Day said he gave her the money orders to hold on to, but he needed them back for his rent. He thought they might be in her black purse, unquote. This is precisely consistent with Mangum's statement about the cashier's checks. Consider that both principals to the transfer of the cashier's checks, Day and Mangum, stated that he gave the cashier's checks to her. Also, the state had failed to present a witness to the transfer of the checks between the two because none existed. Durham Police Officer Curtis Knight, who was on the scene prior to the violent encounter during the wee hours of April 3, 2011, wrote in his report the next day that, quote, I then got out of my car and asked them what was going on. Mr. Day said that Miss Mangum had taken his $700. I told them that they could not be outside making a lot of noise. I then told Mr. Day that if he believed that Crystal had his money, he needed to go take out a warrant on her. He said that he was not going to worry about it. I then told Mr. Day and Miss Mangum that they needed to go inside and to not be loud. They told me that they understood, unquote. Fact is that Day never took out a warrant against Mangum for stealing either his cashier's checks or his money. No one took out a warrant against Mangum for stealing Day's cashier's checks or his money. In other words, there was no complaining witness. The Durham District Attorney's Office took it upon themselves, without a complaining witness and without evidence, to do the impossible by charging Mangum with the larceny charge despite their full knowledge of her innocence, and before a grand jury and under oath. Officer Bond's testimony before the grand jury had to be materially false and perjured in conjunction with the Durham DA's office's inaccurate presentation in order for the jurors to support a larceny of chose in action indictment against Crystal Mangum. Falsus in uno, falsus in omnibus is Latin for a legal maxim that translates to false in one thing, false in everything. It is further defined by uslegal.com as, quote, a Roman legal principle indicating that a witness who willfully falsifies one matter is not credible on any matter. The underlying motive for attorneys to impeach opposing witnesses in court, the principle discredits the rest of their testimony if it is without corroboration, unquote. In the grand jury hearing of April 18, 2011, Durham Police Officer Marianne Bond falsely testified in order to procure the 2-count larceny of chose in action against Mangum. That Officer Bond committed perjury on the larceny charge is irrefutable. According to the maxim, since Bond's testimony in the larceny of chosen action charge was false, her testimony in the murder charge is not credible either. Because Officer Bond was the only witness to testify before the grand jury on April 18th, there can exist no other corroborating testimony and no corroborating evidence. Without doubt, Police Officer Marianne Bond is an impeached witness under this Roman legal maxim, and the entirety of her testimony is therefore discredited. Both indictments should be vacated and Mangum guaranteed a new trial. During her August 15, 2018 motions hearing, in which she sought a summary judgment in her favor on a malicious prosecution civil lawsuit against Bond and the Durham DA's office, Crystal Mangum, representing herself pro se, expressed the Latin tenet in arguing for a new trial.
Also, I'd like to file a motion to be released from our own recognizance because Bond was the only witness to testify before the grand jury. The malicious prosecution charge, she's found guilty of that, then I would ask for a new trial.
As an aside, at the hearing, Mangum, an inmate at Goldsboro's Noose Correctional Institution, was severely disadvantaged by having her notes, papers, and references confiscated prior to her transportation to Durham. She was forced to present her case solely by memory. In January 2018, Sidney Harr, a friend and advocate of Mangum's, began to send out a two-problem yes-no answer questionnaire. The first problem dealt with the Falsus axiom and read, quote, hypothetical problem number 1. Defendant is arrested and charged with stabbing victim. Purportedly, an argument over a cashier's check premeditated the attack. However, following surgery, victim tells officer that he had given defendant the cashier's check to pay the rent for the apartment the two shared. Defendant agrees that victim gave her the cashier's check and there is no evidence to the contrary. Officer records in her police report that victim gave the cashier's check to defendant. During his hospitalization, victim dies due to unspecified complications. A few days later, district attorney goes before a grand jury with only officer as a witness. The grand jury returns an indictment against defendant for murder and an indictment on larceny of chosen action with regards to the cashier's check. 2 years later, defendant's case goes to trial. She is found not guilty on the larceny of chosen action charge, but guilty of second-degree murder. On appeal, defendant noted that officer's grand jury testimony on the larceny indictment was inconsistent with her police report. In other words, her report impeached her testimony before the grand jury. Question number 1. If officer's testimony is materially false with respect to the larceny charge on which defendant was found not guilty, should the conviction on the murder charge be overturned since officer was an impeached and sole grand jury witness? Yes or no? Question number 2. Considering the above scenario to be accurate, are grounds sufficient for defendant to have her murder conviction overturned and granted a new trial? Yes or no? Unquote. Over a period of several months in early 2018, this questionnaire with a self-addressed stamped envelope was sent out by certified mail to nationally renowned and highly respected legal analyst attorneys and non-attorney celebrities and well-regarded non-attorneys. Of nearly 3 dozen surveys mailed to individuals such as Geraldo Rivera, Dan Abrams, Gloria Allred, Lisa Bloom, Gayle King, Whoopi Goldberg, Alan Dershowitz, Jane Meyer, Casey Johnson, Robin Roberts, Anderson Cooper, and others. Harr received only 2 responses. Harr believes that the dearth of response is due to the fact that the intended addressees most likely did not receive the correspondence. Many celebrities and others who receive high volumes of letters have others who sort and sift out those pieces perceived to be unimportant, unworthy of response, and or irrelevant. Then there are those sorters who probably appreciate the importance of the correspondence but prefer not to have anything to do with Crystal Mangum. Many in position to affect justice and positive outcome, such as politicians, are usually the most reticent about any involvement in Mangum's case. For example, in mid-September 2018, Haar ran into Representative Darren Jackson, an attorney by profession. Under drizzling skies, Mr. Jackson, without umbrella or shelter, stood for a good 15 minutes and listened while Haar explained Crystal Mangum's unjust plight. Making no promises, he agreed to meet with Haar to hear what he had to say and told him to make an appointment with his legislative assistant. Haar did so, and after several days, he was anticipating an appointment at any time. Instead, he received an email note from Mr. Jackson sent by his assistant expressing his position. It read as follows: Mr. Haar, after we spoke on the street the other day, you piqued my interest. When I got home that evening, I looked up Miss Mangum's appeal and the record from the trial. I read a lot of it, the briefs from both sides, etc. Your passion is contagious, and certainly I would never want an innocent person to spend one more day in jail. However, it appears from the record that Miss Mangum got a fair trial, a good appeal, and I am quite comfortable that her sentence is based upon the jury verdict and nothing else. Therefore, I will politely decline the meeting to discuss this particular matter any further. As I told you on the street, it wouldn't be my place to interfere anyways. But I think the court system got this one right. Darren Jackson. Unquote. Unlike many, Mr. Jackson showed courtesy to respond about his feelings on the topic and explain his reasons for nixing the meeting with Haar. Many others, including Senator Angela Bryant, a former president of the North Carolina Legislative Black Caucus, have ignored Haar. Ms. Bryant denying him the opportunity to address the group of black legislators. Returning to the questionnaire, of the two responders, one is Janelle Hobson, an associate professor of women's gender and sexuality studies at the University at Albany, State University of New York. She is the author of Body of Evidence, Mediating Race, Globalizing Gender, and Venus in the Dark, Blackness and Beauty in Popular Culture. To the first question in the hypothetical, which is, quote, if officer's testimony is materially false with respect to the larceny charge on which defendant was found not guilty, should indictment on the murder charge be overturned since officer was an impeached and sole grand jury witness? Professor Hobson's answer was yes. As to the second question, quote, considering the above scenario to be accurate, are grounds sufficient for defendant to have her murder conviction overturned and granted a new trial? Professor Hobson's answer was yes as well. The other responder to the questionnaire was world-renowned forensic pathologist, attorney, and author Dr. Cyril Wecht. His response to the first two questions on the survey were yes, similar to Professor Hobson's. It is crystal clear that falsus in uno, falsus in omnibus is the axiom upon which both of their responses to the hypothetical is predicated, and one which has established that both indictments against Crystal Mangum should be invalidated and her second-degree murder conviction overturned. Justice demands it. Sadly, in the Tar Heel state, the authorities, courts, and media have wayward ambitions to provide immunity from prosecution and to conceal the crimes of Durham police officer Marianne, the true felon, while powerful forces simultaneously keep a single black mother of 3 wrongfully incarcerated for a crime she did not commit. The mainstream media being complicit in this grievous injustice by secreting the truths of Crystal Mangum's innocence from the people.